Then if you have any questions, make sure you just type it in the chat and then we'll go over the questions. We'll have a Q&A in the end as well too. Well, happy Thursday, everyone. And my name is Jenny Locke, and we're excited to go over the difference between a trust and a will. It's really important if you have any assets, whether it's property, money, jewelry. Hopefully everyone has some money in their bank accounts, but we just want to ensure proper succession planning. And as a real estate agent and team, we've dealt with a lot of families that have been going through probate. Probate is not a fun thing to go over. And then Emily will go over what exactly probate means and how we can avoid probate by having a trust and a will. So to give a little bit background on myself, my name is Jenny Locke again. I'm the founder of Zen Coast Homes, and we're a local San Francisco Bay Area real estate team. And we also do have partners all around the country. So if you're not in the San Francisco Bay Area, we have real estate partners all around the country that we can help service. And I'm also a real estate agent coach as well too. So we have a partnership with with my husband's company, Zen Coast University, to teach people on how to invest in real estate around the country, buying passive income. My husband and I have bought over 200 properties, 200 units and doors to create passive income. So that's again for our legacy planning, and especially with all the properties we have, it's important to have trusts set up to ensure that we have all of our assets protected as well too, to be able to pass on to our future generations if something were to happen to us, or if I were to be in a state to not be able to make certain decisions. I'm a USC Marshall School of Business graduate, and we have helped over 500 families here in the Bay Area. And we are super excited to get to know you all. If you don't know our team already, we see some familiar names here, but we're excited to continue the educational process. We're a team that focuses on educating first and then helping our clients versus traditional sales agents and real estate agents are focused on the sales portion. And we have a beautiful, amazing team here of different agents, and we service all around the different areas. And some of the great service that we're able to provide for our homeowners and sellers are to be able to help with renovation costs, give you an idea of how to plan for your property if you have a family member who might have passed away and inherited property. We're going through a few of those right now. We're selling pianos, we're selling like cars and other things, and helping them coordinate with that. So we're really excited to meet you folks and see to make sure that you have all your assets and everything protected. And some of our families, this is Donna, who actually inherited her dad's property in South San Francisco. And we also have Cecilia on the right as well too. And they both went through unfortunate events with parents passing away, but we were able to help guide them through the trust process and be able to help renovate their homes to be able to sell for top dollar still in this market. And we're super excited to also introduce our amazing guest speaker today, Emily Wirowek. She's my own estate planner and lawyer and based here in the Bay Area. And what I love about her is like her intelligence and all her knowledge, and also patience as well too. And working with all different types of generations of people, it's really important to be able to have someone who's patient to be able to go through and guide you through the process. So I'll pass it over to you, Emily.
Thank you, Jenny. Can everyone hear me? I hope I was muted there. My name's Emily. As Jenny said, I'm an estate planning attorney and I'm based in the Bay Area. I do love to be patient, and I think it's very important as an attorney that you have patience, especially dealing in the practice area of estate planning. Today, as she said, we're going to talk about the difference between wills and trust, and what is the difference, why is there a difference, and how important that difference is. So Jenny, if you'll hit the next slide. Many people wonder what estate planning is. And estate planning really is just the umbrella, the overarching concept of having a will or a trust or both. A lot of people want to make sure that they're providing for and protecting their spouse, or providing for and protecting their children, whether they're adults or minor children. Lots of people want to make sure they're saving money, especially since they worked hard for that money. Many of my clients, they want to make sure they're in control. They don't want to let go of control, whether it be their home, their bank accounts, their investments, their retirement. They're not ready, to let someone else control it for them, let alone the government. So I hear a lot of my clients and people I meet along the way, I want to avoid the government and its costs. And that is a high priority for many people, right next to making sure they're providing for their spouse and their children. So knowing the difference between a will and a trust can help you do all of those things, caring for your spouse, your children, saving money, and avoiding the government. Next slide. So what is in your estate? You have to start there. You have to know what's in your estate. What is it that you need to think about when you're planning whether a will or a trust is necessary? The basics, really, it's your cash, your bank accounts, checking, savings, CDs, money market accounts. If you have life insurance benefits, many employers offer group term life insurance while you're working for them. Some people have personal policies that they have, term policies or permanent policies. There are retirement accounts, and that's everything from 401k, IRA, SEP IRA, Roth IRA, traditional IRA, 457s, 403bs. If you're a teacher, CalSTRS. If you work for a governmental agency, CalPERS. There's so many retirement types of accounts, and it's important to make sure that those are, one, included in your estate, and that you have the right beneficiaries. Your real estate, as Jenny said earlier, she's helped many families and many clients of mine sell real estate that they've either inherited or they're ready to transition from a larger home to a smaller home or move out of state. So no matter how many pieces of real estate you own, where they're located in the United States, it all is part of your estate. She mentioned selling a piano, going through the car, selling the car, all of that is included as well. So you may think you have some antiques, those are included. You might have some collections, whether it's bobbleheads, stamps, coins, wine. I've heard people have lots of collections of wine, art, it's all included. If you have investment accounts, stocks and bonds, that's included. If you own a business, as Jenny said, that it's her company, Zen Coast University, that she shares with her husband. She also has Zen Coast Real Estate. So there's different entities, when you're talking about what else is in your state, it includes your LLCs, your corporations, your partnerships, your sole proprietorship. And a newer one, cryptocurrency. Not everybody's dipped their toe in that, but for those who have, that is included as well into an estate. And so you have to consider that when you're thinking about what's in my estate and what should I do. Next slide, please. So if you have nothing, what happens? Well, the great state of California, and every state in the United States, has rules on what happens if you die without a will or a trust. This is just to give you 3 of the options. There's many more things written into the code, but if you have a spouse and you don't have children or parents or siblings or children of siblings, no nieces or nephews, then everything in your estate goes to your spouse. However, they have to go through the court system, which Jenny mentioned is probate. That's why we call it a probate estate. If you have a spouse and one child, whether a minor child or an adult, or if you don't have children, but you still have a parent alive or a sibling alive, Half goes to your spouse, half goes to your children, parents, or sibling. Most people are shocked by that when they find out, well, if I die, I would have thought everything goes to my spouse or my partner. That's not how the law is written. And if you die without a will and you have a spouse and more than one child, the spouse gets a third and the children get 2/3, not 12/3, but 2/3. So just know that it's not necessarily what you want if you die without any planning in place. Next slide. So wills, what do wills do? A lot of people I've met in my 14 years of practice have said, well, I have a will. I just need a will. My parents, all they had was a will. My friends, my coworkers, they have a will. That's what they say I need. Yep. A will is a great place to start, but you have to think about that first question of what's in my estate, because a will guarantees the court involvement, and that's through the probate process. And the only way to process a will when you die is through the court system. The judge has to supervise the administration of that will. It's costly. When I say costly, I'm not talking just financially, I'm talking time-wise. If you're in the Bay Area, San Mateo County, San Francisco County, Alameda is almost the worst, right next to Contra Costa County in the Bay Area. Your loved ones aren't going to get through that probate process for less than 1.5 to 2 years. So if you want your loved ones to have immediate access to the home, to your bank accounts, a will isn't going to make that happen. A will is going to slow everything down. The costs, and we'll go through that in a minute, are also financially expensive, but also emotionally expensive. Sometimes when I think about my job, it's not just getting tools in place. I really like to help families and individuals think about relationships and emotions and, what different tools and choices on who's going to make decisions, how that'll affect emotions and relationships. Wills, that's all wide open. The court's going to see it all. They're going to have space for contesting, and it can drag the process on even longer than it normally would. Another thing that people don't like about wills is that it's public. Your will gets filed with the court, and then a probate referee comes in and says, okay, what do you have? What's it worth? And the value of everything is assessed, and that is made public. Everything from your car, your jewelry, your furniture, your piano, to your real estate, your bank accounts, your credit cards, all the debts, it's all public record. And most people really don't like that publicity of their personal assets. And then someone else just kind of assigning a value to all of that. When I say there could be multiple probates, this is key for someone like Jenny in Jenny and Calvin's school, where they're learning how to get real estate in multiple states. You could have a probate in Alabama, in California, in Texas, in Idaho, if you own real estate or other assets in other states. And so it's important that you avoid not only just the one in California, but also in other states. And many people want to make sure that their children or their heirs, as the Hollywood likes to say, everybody coming out of the woodwork, they don't contest the will. And when you go to court, it's wide open, and really anybody can go hire an attorney, because I know there are some bad ones out there. I've seen a lot in the last couple of years because of COVID. People are just getting really entitled, and the attorneys are getting greedy. And unfortunately, that's happening more and more. And people are contesting and challenging wills and challenging trusts. And so a will really opens that up, because everything has to go through the court system. And wills don't control a lot of property. A will doesn't happen, doesn't become effective until someone's died. And it's not going to control your retirement accounts, and it's not going to control things that have a beneficiary designation. So we want to make sure that, you know what a will is and what it does, so you can see that there might be other option that is better. Next slide. So the cost of probate. So I mentioned it's costly. Here's just a breakdown, a sample of what the costs are. California has a law, a statutory fee that says the attorney and your executor or your executrix, if it's a female, get a percentage of the value of everything that's in your estate that's going through the probate court system. It adds up quite quickly, and I don't know an attorney who's going to say no to the probate fees that are in the law. Most of them are going to say yes. Whether it takes them a lot of time or not, they're still going to take the fee, and the executor really is too. So we have an example on the next slide, but it's expensive just to talk about attorney's fees and executor fees for probate. But then you also have appraisals, and that's in the law. A probate referee is the name of the person who gets appointed by the court to come in and say, okay, your real estate's worth this, your business is worth this, you've got this much in your investment accounts, they're worth X. And that probate referee also gets 0.75%, almost 1% of the value of everything that they just appraised for you, which is interesting and fascinating. Many people don't think that's fair because they're the one who are assigning the value, and yet they get a percentage of that. But that's the way the law is written. There are filing fees, there are publication fees, there's so many expenses that add up, several thousands of dollars outside of the attorney fees and executor fees, let alone realtor fees if there's real estate that needs to be sold. So you could have an average cost of administration in a probate for a will of 4 to 10% of the gross value, not I have a home, and it has a mortgage. The gross value is where those fees come from. Next slide. So here's an example to give you a contrast of if you have a home without a mortgage and a home with a mortgage. So the fees come off the top. So the house is valued the same. It's $200,000. But the one example, they have a mortgage on it, a debt on it of $160,000. So your net, cash at the end of it in the first example is $200,000 because there's no debt, no mortgage. But on the other home, in the other example, it's $40,000. The fees are still the same. You're still going to have $16,000 in attorney and executor fees, regardless of the debt and the mortgage. They get paid first before the mortgage and the lender gets paid. And the only entities that come before the attorney and the executor fees are the IRS and the Franchise Tax Board. So if you look at the bottom of this table, you'll see that the effective rate, and that's not including the filing fees, the probate referee fees, and all the other miscellaneous publication fees and so forth, just the attorney and the executor fees on this example, you've effectively got an 8% rate with the no debt, but a 40% rate of cost on the other one with the home that had a mortgage on it. That's expensive. Even if you don't look at it as a percentage and you're just looking at it as dollars, you can create a full comprehensive estate plan for far less than $16,000. And your home in the Bay Area is probably worth far more than $200,000. So we want to make sure that probate is something that you understand. And hopefully you're thinking right now, I really need to avoid this court system. Next slide, please. So how do we do that? With a fully funded trust. There are, hundreds of thousands of attorneys in California, and we all generally call the trust the same name, but it can have many names. It can be a revocable trust. It can be a family trust. It can be a living trust. It can be a revocable living trust. It all means the same thing. And when I say fully funded, I want you to think of it like a suitcase. You're going to pack your suitcase and you're going to make sure it's got the items in it that you may or may not need. It's going to hold your property for ease of transfers, and it's going to give you the ability to put things in and take things out. You, as the person who creates the trust, will be the one who manages it, and that's called a trustee. So while you're alive and well, you wear that hat as well. And when you're incapacitated or deceased, you can set up rules on who's going to take over. We call that person a successor trustee. It can be your kids, it can be your siblings, it can be your parents, it can be a professional fiduciary, it can be a bank or a corporate trustee. There's almost unlimited options on who you can select. And it's really important to think about who you are choosing and who you're choosing as the backup, because that will all play into effect on the relationships and the emotions that are triggered or not triggered when you do become incapacitated or you do die. Next slide, please. So that trust is also going to achieve a few more things for you. If you want to make sure you're in control, it's going to ensure you have control, not just while you're alive, but if you do become mentally incapacitated through dementia or Alzheimer's, and you can still control them after you're deceased. You set the rules for the inheritance. You're going to set the rules for who the successor trustees are, and you're going to set guidelines for care during your disability. You might have children who are minors, who are under the age of 18, and you may think, well, I want to give them some time to grow up a little bit and not use my money, my real estate to fund their fun early 20s. Well, that's a good idea. And so you can put language inside of your trust to really set the rules on that inheritance, that the trustee, whoever you've selected, is going to use the money for your child or children's education, or they're, buying a house or buying a car, getting married, their rent, whatever rules you want to put into the trust. But you can say the children aren't going to be in control of that money until they're 27 or 30. You give them a time to grow up, go to college, go to university, go to trade school, start a job, start a career, start a business, whatever is something that excites your children, let them start that. And then when they're older and hopefully more mature emotionally and mature financially, then let them be in control of it. So you can set that rule inside of your trust. You can also plan for many different situations. So if you have children that are differently abled, I have a younger sister who was born with cognitive deficits, and she's differently able, and she lives at home and she doesn't drive. You can plan for those children. You can still provide for them. They may never, some might, but some may never be able to be in control of their money. And you can plan for that inside of your trust. If you have pets and you want to make sure that they're taken care of, whether it's your, fur babies, as they say, your four-legged friends, your four-legged family members. I've got 2 miniature dachshunds, so I know how that goes. You can plan for them, make sure that they are cared for. You don't have to be, I think her name is Leona Hemsley over in New York, died many years ago, but she left all of her money, millions of money, to her dog. You can do that. You don't have to, but you can provide for your pets. I've got clients who have horses and turtles or tortoises, and they live quite a long time. And so they're providing for them. So you can do that as well. You can also plan inside of a trust for remarriage of your spouse. You might be, married for 40 or 50 years, and you think, gosh, if I died, is my partner going to be susceptible to, a nurse looking for the purse, or Bambi the bimbo, or all the other things that I've heard out there. There's lots of lovely names that people have come up with for what I like to call predators. So you might want to be able to plan for that. And you can do that in a trust. You cannot do that in a will. You might be more charitably inclined or philanthropic, and you can plan for charities in your trust. You can plan for them in multiple types of trust, but you can definitely put that in your fully funded trust. And some of my clients have special religious desires. Maybe they're Jewish or Muslim or Catholic, and they want to make sure certain, provisions are met and upon end of life, and we can provide for that. We can put that in so the kids don't forget or the loved ones don't know. And the trust is easily amendable. You can change it. As long as you have your mental capacity, you're in control. And that's key for many, many people, is being in control and able to change it. I'm not telling you that you need to be like some of my clients who every year, he's in, he's out, he's in, she's out, she's in, she's out. You don't have to, ping pong back and forth every year, but you can change it. Relationships change. Children are born, grandchildren are born, you move, people you've selected might move away, relationships change for that, people might die. So there's many reasons why people want to change it. And that's the beauty of a fully funded revocable trust, is that you can change it. Next slide, please. So if I have a trust, do I need a will? Yes. I get this question all the time. So we have two different things. We have a will and we have a trust. The will, as we said, guarantees the probate process. The trust does not. The trust avoids that probate court process. As long as everything's in the suitcase, sometimes I like to call it a bucket. If you've got everything in the bucket, then we don't have to go through the probate court process. However, and sometimes lenders like to take real estate out of a trust to refinance a property. And the lender forgets to put the property back into the trust after they finish the refinance. So when you have a trust, you have a will. It's not a last will and testament. It's called a pour over will. It literally does what the title says. It pours everything into the trust, just like a tea kettle into a teacup. And that catches those things that got missed, that didn't get put into the trust, or if you did refinance and a lender forgot to put the real estate back into the trust, you don't have to go through that full formal probate process that can cost, 4 to 10% of the value of the real estate and take years potentially. That pour over will catches it and pours it into the trust, and it shortens that process and eliminates a lot of that cost. So yes, if you have a trust, you do want to have a will, but it's called a pour over will. It's that plan B, just in case something's missed. Next slide, please. So when you have a trust, what do you do? Once you've set it up, you need to review it annually is best. Not everybody does that, but try to annually or every 3 years if you can. Life will change. The laws are changing, but life will change. And so when that happens, you want to make sure that your trust is changing with you. What is funding? Everything is in the bucket, right? So if we go back to that question of what's in my estate, confirming that the bank accounts, they've changed ownership to your trust. The investment accounts have changed ownership. The real estate has changed ownership. All of those things are now going to be owned by you, but as trustees of your trust. Your life insurance beneficiaries are the trust. And then your retirement accounts, they're going to have different beneficiaries. Typically, those do not go through the trust. But you want to make sure that all of those steps have been taken, and that's what is called funding. Not every attorney will give you instructions on how to do that. Not every attorney will do some of that for you. In my office, that's part of our plan, is that we want to make sure not only did we set up the bucket, set up the trust, but we want to make sure you get everything in it. Otherwise, it creates that need for that pour over will where you do have to go to court to say, hey, put everything in the bucket. Some people have been divorced, and they might have had a previous spouse as a beneficiary on a retirement account or a life insurance. And so we want to make sure that those beneficiary designations on the retirement accounts match the current estate plan. Some attorneys don't help you with that. And if you don't look at those beneficiaries, then that ex-spouse, that parent, whomever the beneficiary is, will get the assets. They'll get the retirement accounts. They'll get the life insurance. And there's nothing you can do about it. Granted, you are deceased, but there's nothing your loved ones who are still here can do about it. So beneficiary designations, you need to make sure that they are current and correct and matching your estate plan. Otherwise, they won't flow the way you might want them to your kids, to your spouse if you're married now, or if you weren't before, or to the new spouse. You need to let your successors and your agents know that you've chosen them for the job. Some of my clients are like, oh, I'll let them be surprised. It's not a happy birthday surprise. It's not really like that. It's a job. It's work. And it's nice to know ahead of time that you've been selected. Many people think of it as an honor, and it is, but it's also work. And if someone has a heads up that they're going to be your trustee, or they're going to be your power of attorney, or your healthcare agent, that at least lets them know that, okay, if something happens, I actually do need to contact their attorney, or I need to know where the documents are so I can make decisions as needed. Not everyone wants to be transparent like that, but the more transparent you are, at least letting them know that you've done your plan, that they are the backup guardians, that they are the successor trustee, that will make it a little bit easier if something happens. And then you want to make sure you're updating at least your power of attorney, which is the financial document that controls if you're alive but incapacitated, every 3 years. Those powers are constantly changing. For example, in the last 2 years, we've had to update quite a bit because there's now powers regarding credit cards and who can access the credit cards and what can you do with the credit card? Can you use someone's credit card to pay for their expenses? Can you close the credit card? Can you cancel the credit card? Can you pay down the credit card? Can you use someone's funds to do that? So a power of attorney should include provisions regarding, the newer items like credit cards, cryptocurrency, things that are changing. So that's one of the items that you should update if you have a trust, and hopefully you do have a trust and a power of attorney as well. Next slide, please. So when you think about updating, what would trigger that? Everybody's life is going to be different. Their life experiences will be different. Their needs will be different. And so maybe you don't need a will or trust right now. Maybe you don't own any real estate. Maybe you don't have any life insurance. But sometimes if you have children, minor children, you should still plan for that. If you are over the age of 18, you should still have a healthcare directive and a power of attorney. But once you do set something up, no matter where you are on the spectrum of, do I need just the basics of a healthcare directive and power of attorney, or do I own enough assets, and do I have children, or do I have other needs where I need to have a trust in place? Once you do have something in place, these are some of the things that will trigger, hopefully, an update, or at least an opportunity for an update. And that could be life goals that have changed, changing relationships, whether marriage, divorce, death, changing relationships with the people who you've chosen as your agents, asset changes, selling a home, buying a home, deciding you don't like Wells Fargo or Bank of America, moving to the local credit union. Maybe you got a new job. There's a lot of that going on right now. And making sure that the new company, if they offer any benefits, that those benefits they offer, whether it's life insurance, retirement, that those beneficiaries match your estate plan. Maybe you've had a death of a parent and you're inheriting a house, like Jenny's client in the beginning. That changes things, and you may need to update your estate plan, your trust, or maybe create one if you never had one. Sometimes people who have children get lucky and have grandchildren. That can be a reason why you want to update your estate plan, your trust as well. Next slide, please. What happens if you become disabled? So transitioning here a little bit, because not everything in my world in estate planning is about death. We are living in a day and age where science and medicine are such that people are living longer. People are living longer with dementia and Alzheimer's and Parkinson's. People with traumatic brain injuries can recover and become independent again, but that can take time. So if you become disabled, how do we, control the definition of disability? Well, you have to have tools in place to do that. And a trust created can create what's called a disability panel. Many attorneys just say, yep, two physicians. If two physicians say I'm disabled, that's it. Well, physicians are getting a little more skittish about saying, yes, this person has cognitive decline. Yes, this person has dementia or Alzheimer's, and they're not able to make their financial or healthcare decisions. The reason for that is because they don't want to be exposed to liability from children, grandchildren, loved ones for making that decision. And so you can take control of that and say, I want, my spouse to make that decision, or I want my children to be a part of that decision. So you can control the definition of what it means for you specifically to be mentally disabled. And once that decision, that team of individuals, or if it is the two physicians decide that, you want to make sure that you have your durable power of attorney for financial decisions in place. You have your advanced healthcare directive in place for healthcare decisions. Those two are critical. Without those two tools in place, your loved ones will have to go through the court system called a conservatorship. Maybe some of you have experienced that. I call it a living probate. It is expensive. I don't practice in the area of conservatorships, but my colleagues that I know that do, it's $10,000 just to get it set up. And then depending upon the court, you could be checking in every year, 2 years, to confirm, that the person who's been chosen by the court to make those decisions for you is following the law. But if you have a durable power of attorney for financial decisions or an advanced healthcare directive, you avoid that court system. You avoid that cost. And so if you are ever in a situation where you are incapacitated, you've selected the people who are going to make the decisions for you. And that includes your successor trustees for your trust. So hopefully you'll consider making sure that those two tools become part of your plan when you're sitting down with your team or your advisors on whether or not you need a will or a trust. And then making sure that you're asking questions about, well, do I have a power of attorney? Do I have a healthcare directive? Do I need one? Most likely the answer is yes. Next slide, please. So one of the big questions that people have, what happens to when my spouse passes away? Well, when you have a trust, depending upon how you've set the trust up, typically those assets in the trust all go to the surviving spouse. So if your spouse passes, then everything would come to you if that's how your trust is set up. Right now, a lot of attorneys are planning that all of the assets go to the surviving spouse because we don't need to do what's called estate tax planning because the federal limit is quite high. It's about $12.9 million per person. So many people don't need a plan for estate taxes. And so they can just let everything flow to the surviving spouse. As long as your assets are in your trust, then everything still goes to you if your spouse passes away. But if your assets are not in your trust or you don't have a trust, then hopefully you're jointly owning those assets with your spouse, whether it's a bank account, an investment account, or real estate. And then if they are owned jointly, then you can transfer the title to yourself as a surviving spouse. But then you're in a position where you might have a probate when you die. And if you don't have a will, or if you have a will, you'll guarantee that probate court system. And so you need to make sure you have that trust. There are many, many, many steps to be taken when your spouse passes. We have a checklist in our office that we give to our clients. If they're ready and they're wanting it, you need to contact Social Security. You need to contact the VA if there were VA benefits, credit unions, credit card companies, canceling cards, utility companies. If your spouse was the person who was on the PG&E account or on the water bill, the trash bill, you have to take a lot of steps if your spouse passes away. And sometimes it's nice just to have a checklist so you don't forget anything. And that's regardless of if you have a will or a trust. There are many things that, whether you have a will or a trust, you need to make sure that you're doing after your spouse passes. So finding a team that can give you those resources to remind you, okay, you need to go through, you need to do the cell phone, you need to do the utility, you need to close down all the social media. If there's a Facebook or a LinkedIn or Twitter or all the other new ones out there that I'm not familiar with, all of those need to be closed down. So when your spouse passes, if they pass before you, there are steps that you need to take. And having a trust will help keep that organized and making sure the assets still flow to you. And then making sure you're checking off the list of other items. If you have the right team, the right attorney assisting you, they can make that a little bit easier for you. Next slide. What happens when both of you pass away? Well, if you don't have a will and you don't have a trust and all you have is a will, either option, well, then you have a probate. You have to go through the court system. But if you have a trust, your successor trustee, because you've nominated someone to take over, will basically look inside that trust, inside that bucket, and say, what are the rules? What do I need to do? How old are the kids? Or if you nominate your kids to be the successor, all right, we need to start selling things. We need to start making sure mom and dad's, debts are paid, or mom and mom's debts are paid, and their last illness expenses are paid, and we follow their instructions and wishes on cremation and burial. There's quite a bit to do after you've both passed away, and it's important for your loved ones, whether it's children or family members or friends even, to know who was the attorney who assisted in helping create that will or that trust, so that way they can help guide your family, your friends through that process. And some attorneys don't do the administration process. We call it a trust administration when you have a trust, and it's called probate when you have a will. Many attorneys just do estate planning or just probate, but some of us do both, like myself. So if you are, had a parent pass away, first thing to do is to reach out to the attorney who helped create the trust. If they're still practicing, if they're still around, ask them, and they should help guide on the steps to be taken after someone's passed away. What happens to the home and your belongings? That really depends upon whether or not you have a will or a trust. If you have a will, well, it's all going to go through the court system, and a probate referee is going to come in and appraise everything and assess everything, car, like I said, the piano, whatever it is. And it's going to take time to get through and sell all of that. If it's in a trust, then after both of you passed away, the kids or the charities or friends or family members, whoever the successor trustee is going to sell the home, work with someone like Jenny who knows what they're doing when we're dealing with trusts and selling through trusts. It makes it easier when you have a realtor who knows how to process things, and a team supporting the realtor who knows how to process things through a trust and make it happen so it goes quickly and you get the best price for your loved ones. I have a family right now who can't several uncles passed away, and I'm not representing the main, the mom, the grandmother, and they're not moving. And the kids are going, every month that we wait, the cost of the real estate is going down, down, down. And it's important that you talk to the right attorney, talk to the right team to make sure for the real estate that action is being taken so your home can get sold and that your loved ones can get the best price. Next slide, please. So why do trusts work? Well, we went through at the beginning some goals of estate planning: providing for, caring for your spouse, providing for, caring for your children, saving costs, saving money, avoiding the government. Really, the trust achieves all of those things. The trust will take care of you while you're alive. It'll outline what happens if you do become incapacitated. No matter how it happens, dementia, Alzheimer's, Parkinson's, an accident, you get to decide how you want to be taken care of and who's going to make those decisions on your behalf. The trust works because it makes your loved ones aware of your long-term goals, your personal values, and your desires. You can really set up language inside of the trust that says for your children, if you have, younger children, not just necessarily minor, here's what I want you to do. I want you to become a productive member of society. I want you to take care of your family, get a job, be involved in your community, in order to receive the benefits of whatever you leave them. You can put those types of provisions inside of a trust. You really can't do that in a will. And so that's why a trust works well for putting in more than just, here's who's in charge, here's who gets what. And the trust, you can leave provisions for your spouse or significant other if you're not married, or children that are differently abled or have spending problems. I've got clients who've got kids who, get a dime and spend $1. So if you don't want to avoid kids doing that or your significant other doing that, you can plan for those types of situations and circumstances inside of a trust. You really can't do that in the will. Now, the court will do that for you. If you have a will and you have minor children, the court's going to sit on the money until the child turns 18. And then they're going to say, here's your check. 18-year-olds are not emotionally mature enough to handle any large sum of money. And you can define large. It could be $10,000. It can be $100,000. It can be $1 million. They're just not ready for that. And the court, quite frankly, doesn't care. You've turned 18, you're an adult, you're in the majority. Here's your money from mom, dad, whomever it is. So having that trust, you can really control that. But if it's just a will, that's it. That's all the court can do. They can only hold it till they're 18. Next slide, please. So the trust also can protect your assets from creditors. I like to put provisions inside of trust that say, if my beneficiaries, so your children, your loved ones, if they have creditor problems, those creditors can't come after your assets to pay your children's debts or your, loved ones' debts. Most people really don't want their money, if whatever they worked hard for in their life, to go and paying someone else's debts off. And so it's important through the trust to put that language in there. And then, like I said earlier, can't hear you all. It's so different when we're in person. I can hear the laughs, but those predators, those Bambi the bimbos, those nurses with the purse, that you can really protect for those inside of a trust, and you can't in a will. And you save money. I think all of us are very interested and keen on saving money and wanting to, earn as much as we can. And I'm on team spend it for need or joy. It's yours, however you want to spend it. But that doesn't mean you have to spend it on probate, and you don't have to spend it on court fees and governmental fees. Your children, even charities, can do, more with that money than the government, than attorneys. I always say you can either fund my retirement as the attorney by going through probate, or you can fund your retirement by creating a trust. And a lot more people want to fund their own retirement or pay for their kids' college, however you look at it. I've got a 3-year-old. She's going to go to school someday, hopefully. But I'd rather you save your money and, maximize what you've got and avoid paying probate costs and the government fees and save taxes and all of that by having a trust in place. Next slide. So what do you do now that you sat with us here for about an hour? Well, if you have something in place, and I'm sure some of you do, I'm sure some of you have put together a will or a trust on Nolo, on Susie Orman's documents, or LegalZoom or Rocket Lawyer. There's a ton of those online things out there. If you've done something already, great, that's a first step. But review what you have. Make sure it's still current. Make sure that it's what you want and who you want to go to and who you want to be in charge. And if it's something that you found online through a form, it might be time to seek out, competent legal counsel to help you make sure that you've got all the tools. It's not just a trust or a will. Like I mentioned earlier, you can have that power of attorney in place, the healthcare directive. There's many more tools that we give our clients to make sure that they're just getting organized to make it an easier transition for their loved ones. I'm constantly reviewing other attorneys' work or other, LegalZoom setup plans and giving clients the feedback that there might be opportunities to improve what they have. It's important to plan. My tagline when I used to do networking events prior to COVID was, don't be late, plan your estate. You want to make sure you're getting things in place just in case. We've seen over the last, 2.5 years, earthquakes are happening, fires are happening, pandemics, illness. And so it's important it's not just having a car accident anymore, or the risk of riding your bicycle in San Francisco and, meeting a minibus. There's many things out there that can cause an accident or death. And so planning is very, very important. And when I talk to my clients, it's not just about planning for yourself, it's your loved ones. So if you still have parents that are alive or grandparents that are alive, all of that eventually might fall to your shoulders. So it's important to make sure that you are, talking to your loved ones, making sure that they are getting organized themselves, because it'll make your life easier when they do become incapacitated or when they die. And so plan not only for yourself, but talk to your family, talk to your parents, your siblings, your coworkers. It's not just for you, it's for them as well. Next slide. Questions. I want to make sure we left a lot of time for questions, because typically there are. And if you think, well, maybe no one wants to know about this, it's probable that they do. But if you have something that's particular to yourself, it's very specific, and you have a specific circumstance that you want to ask, you are welcome to email me. We can always set up a free consultation to talk about, hey, my mom just died and my brother's in charge and I really don't know what he's doing and he doesn't know what he's doing. I'm happy to help you and give you some feedback on what you can do to make sure things go smoothly.
And if anyone has questions, you can direct message me directly, and then I will facilitate the questions. So first question is a pour over will a specific type of will? And then are there different kinds of wills? And then another question. So those are the main things. If you can elaborate the different types of wills and the pour over will.
Sure. So again, as attorneys, we have to have 5 different names for a will. It can be a will. It can be a last will and testament. It can be just your last will. They all mean the same thing. The will is the document. It can be a holographic will where you handwrite it, but it's a document that says, here's who's in charge. Here's who's getting my stuff when I die. And they have to go through the probate court system. The pour over will is different because it's saying you have a trust and we don't want to go through that probate court system. So all those other named wills, they're all the same thing, but they have different names. That guarantees the probate court system. The pour over will is avoiding that full probate court system because you're saying everything should be in your trust.
And we have a lot of questions coming in, but I just want to share for our team as well too. You can reach out to us in Zen Coast Homes, and I'm just gonna stop the share so we can see beautiful faces here and ask questions. Just gonna pin Mindy like for Emily. So next question here is, how much are average fees to change your trust?
Average fees, again, every attorney is different. In my office, we charge a flat fee, and we always offer a free consultation. So you might think I've got just one little thing that I need to change. But when we actually sit down and talk about it, that one little thing trickles into your trust, which trickles into your pour over will, which trickles into your certificates of trust and all the other ancillary documents. So it might be more than just the one small thing you think it is. It can range anywhere from $1,000 to creating a full new estate plan, depending upon what's going on. And that can be, for an individual, $3,000, for a couple, $4,000. It can be more. Maybe you set up a will or a trust and you didn't get everything into the bucket. So we have to talk to the title company and the county recorder and get things moved in there. So to answer that question, the average cost, it just varies person by person. But we always want to make sure that we're talking to you and understanding what's going on and really offering our time free of charge so you don't feel like you're pressured into working with us before, we know what really is going on.
And if you all know, attorney fees could be $500 to $1,000 an hour. So first is free with Emily. So that's at least $1,000 worth of value there. So I have a specific question. So if we have a client here who do they need a trust if, let's say, they're married with no kids and spouse and have some shared accounts, both names are owners of the LLC, but for their accounts, they're not shared and there's already a beneficiary set up and they already have a will for everything left over.
Okay. So in that scenario, just to recap for everybody, married, no children, they have separate accounts, they have beneficiaries on their accounts, they have other assets that are jointly owned. When you have beneficiaries, one, you want to make sure you have primary beneficiaries and secondary beneficiaries. But when you have like payable and death beneficiaries for bank accounts or investment accounts, for example, that's it. You get the one layer of that. And if those individuals predecease you or pass in a common car accident, then those accounts go through the will and they're going to go through the probate court system. So should you have a trust? Yes, because a trust can give you more layers. They can cover his assets, her assets, her assets, her assets, depending upon the couple, and making sure that they're going to who you want. And if that individual or that charity or loved one is not alive or is incapacitated themselves, you can control all of that in a trust. You can't with just beneficiary designations and a will.
Best to just get a trust as well. So
yeah.
Just go through probate.
Yeah.
And what happens if I don't retitle the account into a trust in the financial institution, but it is listed in the trust document appendix?
Yeah. So at the end of your trust, there's going to be a schedule of assets. And hopefully there's a community property if you're married, and then a spouse one and a spouse two separate property assets. Listing the assets in the schedule does not actually put the asset in the bucket. So many attorneys just create the trust and away you go, off you go. And you think you're good. You think you've done it. You're ready. You've got organized. But if you didn't go to the financial institution and change the ownership into the trust, it is not in the bucket. And that is where that pour over will comes into play and says, okay, I listed it on my schedule of assets, but I didn't get it into my trust by changing the ownership at the financial institution. And the court gets involved and they say, okay, we're going to pour it into the trust. It's a much shorter process, but you still have to go through that and use that pour over will to put that in the trust.
The pour over will be able to cover that case. And if not, if you don't have that, then it will go towards the courts.
Yep.
Should the beneficiary of 401k, 403b, retirement accounts be in the trust name?
Not typically, no. So the federal laws under the Secure Act and Secure Act 2.0 changed things back in 2020, where you used to be able to roll things over from spouse to spouse and they could stretch it out over their lifetime. And then it could go on to children and the children could stretch it out over their lifetime. But all those rules changed. Mm-hmm. And when you have a trust is not a person. And so depending upon the language in the trust, you could be triggering taxes at a very different tax rate than the individual. Trusts, if you have $12,000 or more of income, that's the highest tax rate. So that's a 50% tax rate at the state and federal level. If it's in an individual beneficiary, then the money flows to that individual and they take the money out, on their required minimum distributions and pay taxes based upon their individual tax bracket. So a trust might not be the best case for your beneficiary designations for your 401k, your IRAs, your 403bs. The only thing I think about is if you have a child who's a minor or you have a child who's differently abled, then a trust might be appropriate. But you have to be very specific how you list that beneficiary because you want to make sure you're not triggering the trust tax rate.
And then what are the different types of trusts, such as a revocable trust and like how many different types? Because you mentioned there are a few types of wills, but what are the different types of trusts?
Generally, there's just two types of trust, an irrevocable trust and a revocable trust. The revocable is, like I said earlier, the family trust, the revocable trust, the living trust, the revocable living trust, all the different names, same thing. It's your base foundation for your estate plan. It's the bucket. It's the suitcase, if you will. Irrevocable, there are hundreds of different types of irrevocable trust. People use it for life insurance. They could use it for charitable planning. They can use it for asset protection. They can use it for estate tax planning. There are many different types of irrevocable trust that most, maybe 0.1% of the population need or want to have those types of trust. Majority of us just need to have our revocable trust, the basic foundation plan.
Then when you open a new financial account or buy a new car or do things like that, would you have to update your trust, and how loose can you be in your definition for your assets?
So cars, I don't know anybody who's got a car that really is going to live the lifetime of you. They're made to break down, unfortunately. So in my office, we have what's called an assignment of your personal property, because I know you're going to buy things and you're going to sell things and things are going to break, and maybe kids are going to want them and you're going to give them away. Friends are going to want them and you're going to give it away. So we just say whatever, furniture, furnishings, art, books, automobiles, boats, RVs, electronics, hobby equipment, whatever you have, when you sign your trust and then when you die, it's all included in your trust. So you don't have to keep a laundry list of all of those things because we know those things are going to change. When it comes to real estate, that one I wouldn't be loose with. That one I would be very specific, and I would make sure that that gets into the trust every time you purchase real estate, or you open a new entity and you start a new business or a new bank account. I would keep putting those things into the trust and then going back to your attorney and saying, hey, I need to update my schedule of assets. That updating your schedule of assets should only cost you a couple $100. It shouldn't be that expensive to do that.
Are successor trustees appointed by trustees?
The successor trustees are appointed by you, the person who creates the trust. Mm-hmm. Now, you could put in language if, and I have this sometimes, I don't have any kids, I don't have any family members, I don't know anybody who could be a successor trustee. So we put language in there that says that a third party fiduciary chosen by the beneficiaries, gets appointed upon your death or incapacity. That leaves it up to the beneficiaries, whomever they might be. Most people want to still be in control of that and pick the person that they want. But you can put language in there that leaves it up to the beneficiaries if you just have no idea who to choose.
And then do the terms of the trust that you have created, they're basically cemented after you are disabled or pass away?
Yes. When you lose your mental capacity, if you do, and or when you die, your trust goes from a revocable trust to an irrevocable trust. And the only way for that trust to change after you've died or lost your mental capacity is to go to court. It happens. It's not frequent, but it does happen. Usually it's someone contesting what's in the trust. It's not just someone saying, oh, she forgot to put this in. No, it's usually someone's upset and thinks they're entitled to more. So when you do pass away, it's, for better terms, it's cemented. Yeah.
And how long is a typical process to set up a trust? Assets in mind are primarily cash, 401k, retirement, pension, debt-free home, car with monthly payments still.
Well, in my office, when we get a call or an email from someone, they are ready to set up their estate plan, we know they're ready. So start to finish, if everyone's calendars align, we can have everything done in a week and a half, 2 weeks. It's important to get it done right away. One, because it's top of mind and you're ready. Two, something can happen. I don't have a crystal ball. I don't know what life will bring you or myself. So, in our office, I can't speak for others. Generally, it's a week and a half, 2 weeks from first meeting to signing everything. And then after that, it's, talking to the financial institutions and getting everything put into the trust. Some clients aren't very good at doing that. So we have a wonderful team member, Rachel, on our team, who will politely pester you to make sure you're getting those things done for a while after you've set up your trust.
What's the difference and advantages or disadvantages between doing a trust with your company and your firm, which I have done mine with Emily, versus an online company? And I know that might be like a legal Zoom or something else, but any overarching other company?
So an online company, most likely you're not going to get an actual attorney. You're not going to get someone who's going to sit down and ask you detailed questions and give you feedback on, well, if you chose this, here's your pros and cons. If you select this person, this is what could be the outcome. The online companies aren't going to ask you, which of your children are the more organized, which of your children is the mediator between all of the kids, who's going to be able to understand the dynamics of everything that's going on in your estate. You're just not going to get that personal one-on-one feedback, questions, guidance going through that. You're also not going to get that upon death. Those online firms or online companies, they don't do trust administration. So your children are left going, or your loved ones, if not children, are left going, well, what do we do? Where do we go? How do we process this? When you have an attorney involved, you're creating a relationship. They're really becoming part of your team, just like your, tax advisor who helps you with your tax returns, your financial advisor, if you have one. You're creating a team that's going to help yourself during life, but then also your loved ones after you're gone, process through all of that. So that's the biggest difference, is that you're going to get more hands-on, more advice, more counseling on which decisions to make and how to make them and who to choose, and, feedback on certain questions on who should do what.
How does it work with cars? As from what I know, most people do not buy the car in a trust name. Should it be added in the appendix of all assets, or are there specific rules?
I would not put the title of your car in your trust The DMV is frequently hacked. So why advertise to the public and anyone else that you have a trust? Just like I tell my clients, don't put your trust on your checks. Keep your cars, your title to those in your individual name or your and your spouse's names as an or, not an or. That way, if something happens, it's easy to sell. The DMV has a very simple process through an affidavit when someone dies on transferring title to a loved one, a next of kin, to then sell it. Now, of course, getting an appointment at the DMV is very different. It's not necessarily easy depending upon where you live, but the DMV is not a very difficult process to deal with when someone has died. I just would not advertise to the public that you have a trust and put the title of your vehicles into the trust. And the same goes with checks. Do not advertise to people that you have a trust. There's no reason to do that. You're just inviting predators, curious people to find out what's going on and what's more.
When a trust is completed, how is it filed? Is it with the state, or where do you file it to make it official?
There is no general depository for trusts or any estate planning documents, really. Lots of people want to know about that. There isn't. In my office, we give our clients their originals and we tell them to keep it in a safe place. Your definition of a safe place could be under your bed, could be in your closet, could be in a safe, could be on the bookshelf. People aren't breaking into homes for estate planning documents. They're just not. They're breaking into your home for your TV, your computer, the things they can quickly sell. Unfortunately, I have had clients who lost everything in some of the big, fires in the last few years. We keep an electronic version as a backup. We also give all of our clients an electronic version, so hopefully they keep them in different places. But there's no depository. You just need to let your loved ones know, I've done this. Here's where I'm keeping it in my home. Some firms, they keep all of the original documents for their clients. That's a lot of paper and it's a lot of space. And so more and more firms are not doing that, but some will. It's just a matter of letting your loved ones know where your documents are. That's the key, or at least the firm you worked with so they know who to call if something happens.
However, like with real estate, you do file it with the county, right?
Right. So when you are transferring the real estate into the trust, you're doing a grant deed. And so that does get recorded with the county recorder. That is a public record. It's a great way to find out if your loved one has a trust because you can pull their deed and go, oh, it's not in a trust, or, oh, it is. And there's the firm that helped them create the trust.
And then are there any other benefits of having a home in the trust other than avoiding probate?
Any other benefits? Well, if you become incapacitated, the successor trustee can control it, can sell it, can make repairs, maintenance, pay real estate taxes. People wonder, well, if I just do like a payable on death deed on the real estate. Yes, you could do that. That is allowed currently under California law. But what if that person dies with you? If it's in the trust, you can at least say it goes to my kids. And if one of my kids dies, it goes to my grandkids. You can leave everything to a charity in the end if all of your family members die. If you don't have it in a trust, that those rules won't apply. There are a lot of reasons why having your real estate in a trust is important, not just to avoid probate, but for family reasons, for planning for, tertiary beneficiaries, if you will, making sure someone has access to it if you lose your capacity. There's other reasons.
And then do you only service California, and do you have referrals for Indiana specifically?
Yes, I have no intention of taking another bar exam. I did the big one. I'm done. My family all lives in the Midwest. I'm from the Midwest, and they cannot convince me to take another bar exam. So I do have a list of colleagues throughout the United States that we get together every year for conferences and continuing education. So I'm happy to make recommendations if I know someone, not just in a state, but necessarily like in your city. for someone who could help, who might plan more in line with the way that I plan, more, welcoming and family oriented and a good communicator.
And then can you expand on trust taxes and how those get paid?
Trust taxes. Well, that could mean a lot of things. So we'll focus on the income taxes. So when a trust receives income, typically it's an irrevocable trust, that trust will have to pay taxes on that income. And so it's important for the person who's a trustee to meet with a CPA or an enrolled agent to make sure they're doing everything correctly, because a trust is taxed at a very different tax rate than you or I as individuals. And so the trust will be taxed at, again, if it has 12,000 or more in income, at the highest tax brackets at the federal and state level. And that could be about 50,000 or 50%. So every dollar over $12,000 is getting taxed 50% as a trust income. You want to make sure that you're talking with that tax advisor to make sure that income is getting distributed out so you aren't paying those taxes. If the person who asked the question can maybe clarify if there was another type of tax that they were wanting to know about, if it was estate taxes or gift taxes or real estate taxes, just let me know. We can talk about it.
And then is it easy for an attorney to take over the trust that a different attorney has set up if they retire or you just don't like them anymore? As awesome as you are.
That does happen, unfortunately. Like I said, relationships change. Yes, it's easy. If you have your documents, it's very easy. You don't even have to contact the other attorney because you already have everything. You just go to the new attorney. If your prior firm is controlling your documents, they have them, then you just have the new firm you want to work with prepare a letter, you sign it, they send it to the old attorney, and that firm has to send over your file, has to send over your documents. Again, that's one of the reasons why I practice the way I do. I want my relationships with my clients to be based on trust and respect and that they like me, not that they feel like I own them because I have their documents and I'm not letting go of them. So.
And then the person who asked, they would like you to elaborate on the estate taxes and then just something as well too on the real estate side. If you do inherit a property, it is important to get a value on the property and appraisal on the property because there's a stepped up basis on the estate tax. But if you can elaborate a little bit what that means. And
yeah, taxes, everybody, we're saving it for the end. You're going to just be bored to death now. Estate taxes. So that is a federal tax that happens when you die. Everybody is exposed to it. There is a federal exemption right now. It's approximately 12.9 million per person. So if you're married, you have, 26 million, give or take, an exemption. So if everything that was in that first question, one of those first slides, it says, what's in my estate? If all of that totals less than the current exemption, that 12.9 million right now, then you don't pay any estate taxes. No, other people might call them death taxes because they happen when you die. The state of California does not have an inheritance tax right now or a state estate tax. I think there's approximately 13 states that do not have a state inheritance tax or state estate tax. So while it may stink to pay income taxes in California, California is a great place to die because you don't have the inheritance tax or the estate tax when you die. So as long as you're under that exemption in the states where you live when you retire, when you die, then you won't have the state estate tax. But if you're over, like Hawaii, I think I had a client who had some real estate there, was 30 or 35% tax. That was just a piece of real estate valued at 800,000, still had to pay the taxes. It's crazy. So estate taxes are just right now for California residents at a federal level. With regard to the second comment that Jenny was, talking about and asking, yes, when you die, your real estate, you do want to get it appraised, but not just your real estate, any stocks and bonds. When you get them valued at your date of death, Your spouse, if you're survived by a spouse, gets what's called a step up in basis for income taxes. And when it goes from parent to child, they too, under current federal tax law, get a step up in basis. So an example of that would be, let's say I bought a stock of Apple stock for $1 20 years ago, but now it's worth $1,000. And when I die, there's a $999 gain. But I'm married, so my husband now gets a new basis of $1,000, and he doesn't have to pay the 20% tax on that $999. The same would happen when he dies and it goes to our daughter. The same concept works for real estate. So if you bought your home for $10,000 or $100,000, and when you die, it's worth $1 million, your spouse gets a new income tax basis of that $1 million, and they don't have to pay the capital gains taxes on the growth. And then again, when the last spouse parent dies, it goes to the kids if there are children, and they too get a step up in basis for income taxes and do not have to pay the capital gains taxes. So it is important to get those appraisals on date of death so you know what those values are.
What if a trust attorney company closes down for some reason? For example, that attorney passes away, or they just don't operate anymore, lost their bar. What happens? Does it transfer to another attorney service and start all over again?
No. So attorneys are supposed to have what's called a practice administrator nominated through their malpractice insurance. So if they die, if they retire, if they lose their license for whatever reason, there should be someone nominated to take over, especially if they've lost their license or they've died. But many don't even have those individuals nominated. And so those estate planning clients are just kind of floating out there in the universe, not really having a home. Their documents, if their originals were still with that attorney or that firm, I mean, there's been many documents that are just lost. I mean, I'm on a listserv of attorneys in the Bay Area, and I see all the time, does anyone know where so-and-so's files went? And no one seems to know. So it's important that your attorney have their own estate plan in place and their own plan in place, especially upon death. Retirement, they're in a little more control over that. They can send a letter to their client saying, hey, I'm retiring, and I'm, if you want to, you're welcome to work with so-and-so, as is who I recommend to take over my files. It doesn't mean you have to redo your estate plan. If it's a good estate plan, there shouldn't be anything that you need to update. But if you haven't looked at it in 10 or 12 or 15 years, then maybe it is time to look at it with the new attorney.
And then two people asked this question, but what are the mechanics of naming a foreign national as a beneficiary? And then the other way another person asked, are there any restrictions for any beneficiaries that are overseas, not US citizens?
So mechanics of that. Well, you can truly name anyone you want as a beneficiary. I've got lots of clients that have listed, siblings or children who are overseas and all over the world, whether it's Europe, Asia, Africa, you can list anyone. The tricks are, how do you get the money to them? Can you wire it to them? Do they have an account? And what will be, if any, the taxes at the, federal and state level, if any, to that individual? I leave the tax questions to the CPAs and the EAs. They know that stuff far better than I do. Not always will there be any tax consequences to having a foreign national as a beneficiary. Most times there aren't, but sometimes there could be. The other portion to that question is naming a foreign national, maybe it's a sibling, as your trustee. That I would highly consider someone considering someone else. You want a trustee who has a social security number. Otherwise, your trust could be considered a foreign trust when you die and that sibling, parent, whomever outside of the country, foreign national, takes over the trust. Those are taxed at completely different rates. So we really don't want to turn a revocable trust into a foreign trust by having a sibling who's, lives in England as the trustee.
Then who writes the pour over will?
The attorney should. If you have an attorney, they should do it at the same time that you do your trust. and all your other tools, or if you've used an online tool, maybe they didn't even suggest a pour over will. So another reason why you should use an attorney, especially an attorney who knows what they're doing.
Then to the topic of real estate handover to spouse or children, pay income tax means tax bracket will be much higher.
I think, is that question asking about the capital gains? Is that what they're asking?
Yes, the capital gains tax.
Yeah, so it's when a spouse passes away, the date of death value is the value of the real estate for the surviving spouse. If the surviving spouse does not sell the real estate, then there's no capital gains for that person to pay. There's no taxes for that person to pay. Same goes from parent to children. If the children don't sell the real estate, then there's no capital gains for them to pay. What happens oftentimes, and Jenny and her team sees this, is mom will pass away, they inherit the property, you get the appraisal, you know the date of death value, and unfortunately until most recently, property started to decline recently, but before that, prices were going up and up and up. And so you get a value on date of death that it was $1 million. And then by the time you finally sold, it was worth $1.2 million. So that $200,000 difference, they would have to pay capital gains taxes, but on the value as of date of death, no, they don't have to pay any capital gains taxes.
Let's say if there's like a husband and wife, and then husband passed away and the value is worth $1 million, does the wife still get the $250,000 exemption?
Yes. Yeah, that's different. So yeah, when we're talking about exemptions, yes. Mm-hmm. So the wife would have the $1 million date of death value, and it's sold for, 1.25. She'd have her $250,000 exemption through the tax code and zero capital gains.
And then let's say if the same case, but children sell it, it's worth $1 million, and it went date of death and then worth 1.2 million, but minus real estate commissions, minus any repairs, any of that. So let's say that was $100,000. So then the tax would only be on $100,000.
Correct, which would be about 20%, so $20,000.
Mm-hmm. And then does the step-up basis occur only if the property is in the trust name, or would it apply if they had it in their single name?
It does apply when you have it in the trust, but not always when it's just in your individual name. So if it's a joint tenancy, if it's husband and husband, joint tenants, wife and wife, joint tenants, husband and wife, joint tenants, you're only going to get a step up in basis on half. You have to have it as husband and wife as community property. And I've been steering a lot of my friends and family to make sure they don't take title to real estate or stocks and bonds as joint tenants. Take it as community property, because if you take it as community property, you get a full 100% step up in basis. But if it's joint tenants, it's only half, and the half of the deceased spouses, that is a step up in basis.
If let's say a couple, their boyfriend and girlfriend, they're not married yet and they buy a house, they wouldn't be able to purchase under community property though, right? They have to purchase under
right. They're going to point they don't have to purchase as joint tenants. They can purchase as tenants in common. And so, it doesn't have to be 50-50. If let's say girlfriend puts down the full down payment and, she's going to pay majority of the mortgage, then she can have, 70% and boyfriend can have 30%. Mm-hmm. It doesn't have to be a 50-50. But I would still steer them as having it as tenants in common. Mm-hmm. And then having their own trust set up, because maybe they never want to get married. That's fine. We don't have common law marriage in California where, you can say we've been together for 7 years and I call, her my wife and him my husband. We don't have that like other states do. So I would recommend they take it as tenants in common for whatever percentage they own, and then put their percentage in their trust and make sure they're selecting the right trustees. Because I have seen one of them has an accident and they're incapacitated. Their parents come in and they get the conservatorship, and they make it really hard for the partner, the boyfriend, the girlfriend, to continue to live in that home. And then effectively forcing them to sell it. And then they're homeless. But I mean, they've got money hopefully from the sale of the home, but homeless because someone lost their capacity, had an accident, and they didn't have a plan in place, didn't have a trust.
And then let's say if they did get the tenants in common and then one passes away, would it still be stepped up to the full value?
Not for boyfriend and girlfriend, no.
Okay, so they have to be married.
Yep.
So that is a benefit of marriage there.
Unfortunately, there are lots of tax benefits being married. That doesn't mean you have to, but there are tax benefits.
Perfect. And then once you, oh, can the trust be allocated towards a nonprofit instead of family members?
Yes, you can definitely list a nonprofit, a church, a favorite charity as a beneficiary, 100% beneficiary. I've had someone who had 20 different beneficiaries that are all charities and they just chose various percentages for them. You can most definitely do that.
Mm-hmm. Then once you paid for trusts, is there a maintenance fee, a fee to transfer to another attorney, or charge to distribute assets upon your death?
Great question. So maintenance fee depends on the firm. So in our office, we have a client care program, which is just an annual fee of $500. That covers all communications with you, your team, your advisors, your successor agents if you've lost your capacity, and it includes all of your updates if ever you want to make an update. You don't have to join our client care program. We recommend it. It's much cheaper than just going along and 10 years later, I've got to do an update and maybe it's more than you thought it was going to be. Send an email. I have this question. I don't like billable hours. I don't know an attorney that really does, but that's how most people keep track of their time and charge for it. So we prefer to have the flat fee client care program. It's just easier for everybody and more user friendly generally. When you transfer to another firm, I would hope there's not a fee for that. We don't charge for that. We welcome new clients all the time. But I can't speak for other firms. So if they charge you to send, your documents to someone else, I would be pretty darn upset about that. And they shouldn't be charging for that, but it just depends what your agreement with them was. If they charge you per, printing and paper and copy and all of that. Yeah. And then as far as the question about, distributing the assets upon death, yes, there are fees for that. That process is different than the estate plan. That's trust administration. And in our office, as long as there's no contesting, there's no fighting, it's a flat fee. We just, it's every tool we're creating, it's a flat fee. And so the beneficiaries know what they're getting into up front. But as soon as someone goes and hires an attorney, it just costs get out of control because, as Jenny said, attorneys charge usually anywhere from $500 to $1,000 an hour. And every email is going to cost you, if it's a $500 an hourly rate, it's going to cost you $50 to $100 per email. That's receiving an email and then sending an email. So it's expensive if litigation attorneys get involved, and gets very expensive.
And we're dealing with the probate right now. So any calls that need to be happening, let's say there's 6 other inherited like siblings, like every single sibling is going to try to call the attorney. So every call will be billable typically on a probate situation.
Yeah.
And then are there any tax consequences from changing title from a separate property to a community property?
No, if let's say you purchased a home while you were single and then you got married, for real estate taxes, you should, as long as you fill out the correct forms, it should be an exempt transfer with your county recorder, county assessor. Income taxes, again, you're just providing a better benefit to your spouse because now they're going to get a step up in basis on 100% of the property. And yourself, if your spouse is the first to die, you get the benefit too. So it goes both ways.
And then if someone has no wife or children and want to leave everything to their sister, but they have 2 brothers, are there any complications?
I don't know those brothers. There could be. It just depends upon those brothers and the relationship, but you can put language inside your trust that says, I am leaving 100% of everything to my sister. My brothers are specifically disinherited, intentionally omitted. Use language of that sort. That means that they're not to get anything. And you can also go further by adding a no contest clause and saying, look, if you contest this, you can start that process. And I've got, again, like I said, this last 2 years, people have been really entitled and still hiring greedy, grubby, greasy, awful attorneys that give attorneys a bad name to file those suits. And they get so far along, and then the judge says, wait a minute, there's a no contest clause in here. Get out of my courtroom. But they've already spent $30,000, to fight it. So you want to make sure you got those things locked up tight inside of the trust when you're saying, no, I don't want my siblings. And if everybody is, getting along and communicative, and you feel comfortable saying to your brothers, look, I'm planning this, I'm providing for my sister for X, Y, and Z reasons. If you're able to do that, great. That hopefully diffuses the emotions and the frustration and the anger after you're gone, when they're going, why not me? So.
And then I've seen a trust actually with a seller that we dealt with, and it said for that situation, basically one sibling gets almost everything, like everything, the property and everything. And then the other two siblings got $100 each, because then it's harder for, at least they got something. And this is clear cut of what they will receive versus contesting against them.
Yeah.
Yeah. That sister was not happy when she was like, $100 like a week or a month. Nope. Just $100 flat is all you get.
Yeah.
Mm-hmm. And then can you go over again why the trust should not be a beneficiary of a 401k? Does this also apply for IRAs?
IRAs, yes, yes. Think of a 401k, IRAs all as retirement accounts. So 403bs, 457s, Roths, traditional SEP IRAs, rollover inherited IRAs. There's a new federal laws regarding who can roll over, who can stretch out those retirement accounts over their lifetime, what their required minimum distributions are, when they have to take them out, and what the taxes are. And so if you have a trust as a beneficiary, generally I would say it's okay if there's a minor child involved, or an individual who's differently able, doesn't even have to be a child, who you want to be a beneficiary. You could list those trusts as beneficiaries if you're specifically listing them in a certain way. Otherwise, if all of your beneficiaries are a spouse or a partner or siblings or parents or kids that are over the age of, let's say, 18, then just list them directly, because they'll be able to take the money out according to the new laws when they're supposed to, and pay the taxes on those, money, not a Roth, but all the others. When they take the money out, they'll pay it on their tax bracket. It will increase their tax bracket potentially on how much money they're taking out. But at least it'll be hopefully a lower tax rate than a trust tax rate.
Okay. Thank you so much. And then everyone, thank you so much, Emily. And then our next, if you like this, there's a lot more topics in estate planning, and let us know what topics. Just email me. I'll go ahead and put my email in the chat. If you want a direct introduction over to Emily, we'll go ahead and make that introduction. I know some people ask for referrals and out of area, so we'll make that connection as well too. And our next webinar will likely be on March 2nd, so that will be Thursday. So we're going to go over the home buying benefits and ensuring the right process, and especially in making sure a lot of our clients are like, how should we set up joint tenancy and community property? So this was very helpful for us as well too. So thank you so much. And we also have an investment webinar if you're interested on how to build generational wealth in real estate and how we were able to buy investment properties. That's going to be on February 23rd as well too. So that's, we put in the link there. So that will be how we've been able to buy all of our passive income properties, investments, build over 200 plus units, and have that passive income. That definitely needs to be in trust, because it will be very complicated in probate in like 10 different states. Yeah. Awesome. Perfect. Well, have a great night, everyone. And we'll see you on the next call on February 23rd.
Thank you.
Bye.